So what is an expunction and what is a non-disclosure, and how do they differ in Texas? There are two ways to clean up your record of a criminal case, of an arrest, a charge in a criminal case in Texas. And that is a petition for expunction on the one hand and a petition for non-disclosure on the other. So an expunction, in short, completely removes all records related to your case. So if you think of the days before computers, where your record, if you're a Texan, was in a government building in some filing cabinet in Austin, an expunction would be finding your name, taking the file out, and removing everything related to this case and shredding it, burning it, whatever. It's gone. Okay? A non-disclosure, on the other hand, those files stay in that record. They are then sealed from the public. Only certain entities can see records that have been non-disclosed by a court. So, for instance, courts, prosecutors, law enforcement, they can see records that have been sealed. There's a whole list of other agencies and government entities and whatnot that can see it. So it's important, if you're going for a non-disclosure and you're thinking about this for the future, that you go over this with your lawyer and see whether that's going to be right for you, right? If you are a professional like a lawyer, doctor, a teacher, a nurse, the licensing bodies that govern those professions are amongst the entities that can still see sealed non-disclosed records, right? So a lawyer, a nurse, a doctor thinking, I'll get my deferred adjudication probation non-disclosed and then I'll be all good, the licensing agency will still be able to see it. So there's a whole list of examples like that, so it's something to think about. So like I said, an expunction is the removal of all the records. A non-disclosure is the sealing of the records. The other big difference is what case resolutions are eligible for what. And this is the number one mistake I hear people make. They call my office and they say, I want to get my case expunged, and then I got deferred probation, or I was convicted, or it's still ongoing. None of those cases are eligible for expunction. So let's start with expunction. What is eligible for expunction? If your case, you go to trial and you were acquitted, you were found not guilty, you're automatically entitled to an expunction. If your case was dismissed, then you're almost certainly entitled to an expunction. I say almost certainly because there's some very small exceptions, but basically once the statute of limitations period for your case expires, that's the length of time that the law enforcement and prosecuting authorities, the DA's office, have to bring a charge against you. So for misdemeanors, it's 2 years. For felonies, it's 3 years, 5 years, 8 years, 10 years, all the way to no limitation. So if you're charged with, let's say, a low-level felony and they have 3 years to file that case, they dismiss the case, you have to wait until the expiration of that 3 years from the original offense date, from when you allegedly committed that supposed crime. Then you become eligible for an expunction because they're no longer able to file that charge, refile that charge after it's been dismissed. So acquittals, dismissals are both eligible for expunction. Now, I said there are exceptions. You can hear one right there. It's when the statute of limitations expires. So there are some cases, like murder, that have no limitation whatsoever. Well, as crazy as it sounds, any case that has no limitation, even though they've dismissed it because they figured out they have the wrong person or whatever, you can never get that arrest, that charge fully expunged. So beyond dismissals, then of course we have PTIs, pretrial intervention programs, sometimes called pretrial diversion programs. And we've talked about that in previous videos, where you go through a program, you don't plead guilty, you don't do probation, you successfully complete the program. At the end, they dismiss your case and you're eligible for an immediate expunction when you do a PTI. So we've talked about expunctions. What is eligible for non-disclosure? That's simple. You successfully complete deferred adjudication probation. That's it. Texas just a few years ago opened a small sliver of a window for convictions. That if somebody had a really bad lawyer, or I don't know what other example there would be, where they took a conviction when they probably should have gotten deferred. They had no prior record and they've never been in trouble since. There's a small window where you can get those non-disclosed. But 99% of all non-disclosures I see are successful completion of deferred probation. Now, there are certain offenses that are never eligible for non-disclosure, even though you get deferred and even though you successfully complete and you get your case discharged. And those are, for instance, like family violence cases, affirmative findings of family violence, never going to be eligible for non-disclosure. Sex offenses, they're never going to be eligible for non-disclosure. Injury to a child or elderly or disabled person, never going to be eligible for non-disclosure. So some cases, even though you get deferred, and it's a small list, but some cases can never get the records non-disclosed. And then finally, unlike most expunctions, where if you do a PTI, it's immediate, there is a waiting period before you can get a non-disclosure. And so the non-disclosure requires that 1, you successfully complete your probation, and then 2, you commit no new offenses, no convictions, no more deferred probation for any offense above a Class C traffic offense, like a speeding ticket, during your probation, and then for whatever the waiting period is after that. So for some misdemeanors, there's 0 waiting period. So once you complete the deferred, you can immediately apply for a non-disclosure. For other misdemeanors, there's a 2-year waiting period. And for all felonies, there's a 5-year waiting period on top of the probation. So if you do 10 years, the maximum length of deferred probation on a felony in Texas, you're going to wait 15 years of completely squeaky clean record before you can get that non-disclosed. And of course, like we talked about earlier, that non-disclosure is sealing. It's still there, and certain entities can still see it. So that's the difference between an expunction and a non-disclosure. They're very similar, but they have very big differences that are important to understand when you're trying to decide what the right outcome is for your case. So it's important that you understand this and that you have a good criminal defense attorney that can walk through this with you and help explain it so that you can make a full, educated decision about what's best for you.